Honorable Harold Desires. Please be seated.
Good morning. Welcome to the First District Court of Appeals. I hope everyone had a great weekend. We're having a nice fall so far. So today is Monday, September 8th. We have 4 cases on this morning's docket. Only 2 are scheduled to argue this morning. I'll be calling out all 4 cases. Nevertheless, the first 2 that I'll be calling are the ones that are scheduled to argue. If attorneys can please identify themselves and their readiness to proceed. So the first, no, that's okay, no worries, no worry. So the first case is case number C240210, David Ostenji et al. Versus Catherine France et al. Yes, good morning. Good morning.
Good morning, Lana Linder, Millingburg, I'm not the applicability.
Good morning. All right, the next case is case number C240545, Estate of Robert D. Hodry, deceased, versus Duke Realty Corp. et al.
Christopher Penny on behalf of the appellant and cross-appellee. We're prepared to proceed.
Okay.
Your Honor, Dan Idelson with Key Complexities on behalf of the defendants, appellees/cross-appellants. Ready to proceed.
Okay. The next 2 cases have submitted on the briefs. They are case number 24622, State of Ohio versus Zachary Kinman, case number 250056, State of Ohio versus Brian Everett. And with that, we will begin with Ostenji. When you're ready, you can come up to the podium.
Thank you, Your Honor.
I'd like to also introduce Ms. Wainscott. Alex Wainscott's an associate in our firm, and he's the one who drafted our brief and did such an excellent job on that. So,
Okay. Welcome.
ready when the court's ready.
All right, whenever you're ready. Would you like to reserve time?
I'll reserve 5 minutes, please.
All right, you can start whenever
May it
you're
please
ready.
the court. Does the court need any recitation of facts? Okay. Your Honors, this case is relatively narrow from our perspective. 2 assignments of error. The first assignment of error is pretty pinched into one category, which is, does a mere technical violation of the CSPA, in this instance through the Home Sales Solicitation Act, does it enable the magistrate in this case to award full expectancy damages for this mere technical violation? So the technical violation we're discussing in this instance is whether or not a cancellation notice.
Is it about expectancy damages, or is it about workmanship damages?
Well, in this
I know
instance,
that that's kind of, there's some intertwining there. But
yes, it absolutely is. In this instance, I believe the appellee will argue that that is the same thing, that their expectation was that the work would be performed in a workmanlike manner. As a result, if it's not performed in a workmanlike manner, they should receive their damages. But it's our position, and I think the case law and the statute are very clear, that those damages don't get awarded unless they specifically arise from the violation at issue. And in this instance, the only violation that was ever adjudicated was whether or not a 3-day cancellation notice was provided in the contract. So we don't dispute that there's not a 3-day cancellation notice.
What sort of damages would you say could be, have a nexus to the violation in this case?
In this case, the statutory damages, which are the $200 technical violation damages, the statutory monetary damages that are awarded. And the reason I say that is this. The Scott case, which we cite in our reply, is very clear. It's of all the cases cited in any of the briefing, it's the most directly on point factually. But in that case, the court made clear.
That's the 10th District case.
That's correct, Your Honor.
Okay.
And in that case, the court made clear that when you have a mere technical violation of a cancellation or the ability to in that instance, change workshops for your automobile, but when you have a mere technical violation, unless the violation arises directly from that that issue, then you don't get your expectancy interest, you get the statutory damages, which in this instance is $200. And what's been argued at the court below and what was successful.
So I just want to make sure I understand what you're saying. Are you saying that solely the $200 is the only damages that would have a nexus to the violation?
In the adjudicated violation, yes. And that's really the crux of the issue.
What I'm asking is in a broader sense, not in this case, not in the
My
facts of this
apologies.
case.
No, in a
It's
broader
okay.
sense, it could be the expectancy interest. But in our case, we don't have evidence before the trial court that establishes that the expectancy interest should have been what was considered. The reason being is that when Ms. Linder moved for summary judgment, she moved for summary judgment on the grounds that there was no cancellation notice in the contract. That was it.
Were the actual damages litigated below, though? They were presented to the magistrate?
I would argue they were not litigated. I would argue that testimony was presented factually, but I would argue they're not litigated. And the distinction I would make is that when Judge Giz sent this case to the magistrate, she specifically sent it to the magistrate on a very, very, very limited issue, which is what are the damages that stem from the technical violation of not including the cancellation notice?
Did she say the technical violation?
She didn't use that language. I mean, her order was, I think, 2 paragraphs.
It was basically go back for a damages hearing.
On the summary judgment motion was only the failure to provide the cancellation notice. It had nothing to do with the workmanlike condition.
So if you were to go back, wouldn't you effectively end up retrying the damages issue?
Well, potentially. However, we would retry it to the judge sitting with authority to rule on the issue. We'd have a full trial on the issue because it was not ruled on summary judgment. We'd have an opportunity to prepare, file pretrial briefs, do all the things that you would do for a trial instead of going into a magistrate's hearing, which was limited to one particular issue.
And at the magistrate's hearing, in terms of the damages that were presented, was the work completed, or was it more like a estimate?
Well, I think from our perspective, the work was completed. I don't know what they would argue. The work was completed and the contract was paid. There was back and forth between the parties with respect to whether or not any follow-up work should be completed, but then the relationship deteriorated and that issue was never able to resolve until a court action was filed. But
couldn't it be argued that had they been provided the cancellation notice, they wouldn't have gone forward and therefore wouldn't have had the poor workmanship performed on the home and the damages that flowed from that?
without sounding flippant, Your Honor, they could have argued anything, right? And so my direct response to you would be, they did argue that in a sense. However, the case law they rely on says that's not how this works. The case law they rely on says if you fail to provide a 3-day cancellation notice and the work, then you're not permitted to begin work within that 3-day period. That's what the case law says. It doesn't say you can never begin work, which is what their brief insinuates. It actually says that you can only not begin within the 3-day cancellation period. After that fact, you're permitted to begin work, especially when, as in this instance, you were paid. I think they expected my client to show up and perform work. If you look at the contracts that are in the record, the contracts make it pretty clear that the work was not started within that 3-day period. There's actually nothing in the record that indicates that the work was started within that 3-day period. So that's why the expectancy interest here isn't applicable. If they had started on day one and the work was bad and my client came in and said, no, you can't cancel, there's no cancellation notice in this contract, then I'd say, okay, expectancy interest has been triggered. But that's not what happened. It was a few days delayed beyond the 72-hour period that was required underneath the cancellation notice for the first part of the work, and it was a 2-week period for the second part of the work. So there was never an intent to cancel this contract, and the testimony bears that out. Ms. Slattery was asked that, or Ms. France was asked that question in cross-examination at the magistrate's hearing. Did you ever try to cancel? No, I did not. Did you in fact pay for the work? Yes, I did. So we just look at this as two separate issues. One's not before the court, which is whether or not the work was completed in a workmanlike fashion. That was never adjudicated. And one that is, it was adjudicated that there was no cancellation notice within the original contract, and therefore a technical violation occurred. Whether that's my language or all the courts that interpret the case's language and not cited by Judge Giz or Magistrate Baradon, that's probably true. I don't recall them calling it a technical violation. But what what Judge Giz did say, if I can be given just a moment here, she did say that our argument fails to recognize that the statutory award of $200 only applies when the complaining party cannot establish her actual damages. In this instance, We haven't adjudicated whether or not the work was in a workmanlike fashion or not. So she hasn't established her actual damages.
Well, wouldn't they say that what was litigated below in front of the magistrate in terms of the damages presentation that they put on was a litigation of the workmanship?
I believe, so they went into a hearing with the hope and expectation that they could present that as damages. Judge Baradon let them present that as damages. He then ruled on it that there was in fact their damages, but they still don't have an order from Judge Giz saying that under the CSPA, you violated the workmanlike standard. There's no order from the court saying that. And
So if you go back, you're basically going to go back, have a full other motion for summary judgment on that basis, having a technical violation and a workmanship violation, and then another damages hearing, then more attorney fees.
Well, that presumes we lose. So we didn't get to adjudicate the issue. So I'm not going to make the assumption that we're going to lose. We may. And if we do lose at summary judgment, there is a damages hearing that's directed specifically at this issue, and we lose, then you won't see us again. But we have that right to adjudicate the issue. Again, the orders are very simple. I mean, the judge gave a one-page order that said, you violated the CSPA by not providing the technical cancellation policy in there. Therefore, decide what your damages are. And then we went to the damages hearing, and if you look at the record.
Does the order in any way foreclose France from pursuing a violation of the workmanship
No.
of the paint job?
It would be my position that what Baradon should have done is grant them damages on the technical violation, because we don't dispute that there was a technical violation, then send it back to the judge for her to determine the rest of the case.
Because what you're saying is that was never actually
Correct.
presented, adjudicated. or
Correct.
anything,
And
other than the presentation via
right.
damages, but damages comes after a determination on the
That's
merits.
right. And so the damages should have been limited to the violation that was actually adjudicated, which is the failure to provide the cancellation notice. It should not have been adjudicated on the basis that there was a workmanlike issue. Now, I think they were within the rights to present that evidence and hope that the court would award its damages, but we argued very hard and strenuously and timely that that was an inappropriate measure of damages in this case. We filed a pre-hearing brief with Judge Baradon raising this
I'm just going to tell
issue.
you,
Time to
Yeah.
Okay. In any event, we raised the issue multiple times, and procedurally, I'm not aware of any action I've ever been a part of where
okay, thank you.
you're entitled to do that.
Good morning.
Good morning. May it please the court. Alana Linder with Manley Burke on behalf of the appellee Catherine Slattery, nee France. If I may, I'd like to very briefly begin by addressing the second assignment of error, because I think that's a little bit more of a straightforward procedural question that can be quickly disposed of. And as we mentioned in our brief, the defamation claim that the appellants initially filed is not before this court in any live way, and therefore it is a moot issue. As the record reflects, the trial court both dismissed the defamation claim as a discovery violation, which they have properly appealed, but on the same day, the court also granted summary judgment in the appellee's favor in its entirety on the defamation claim.
Well, that's the part that's a little bit nebulous to me, because the motion speaks to the Google review, but there were other facts, other claims of defamation in the complaint. So when I look at the motion, it only seems to speak to only one of the defamation claims. And then when I look at the language of the entry, you know, it could be read as it could be read either way, but it really can clearly be read as addressing that which was raised in the summary judgment.
I take your point, Your Honor. I would argue that to the extent that there is a basis to
I
challenge.
don't know if it's a big deal. I mean, it's either,
Sure.
you know, it's mooted out, or
I
it's
believe it's
partially
been-
mooted out and the rest of it gets addressed on the arguments.
Sure. I believe it's been waived by virtue of them not appealing that issue. It's not before the court with respect to the summary judgment. They've only chosen to appeal the dismissal as a discovery violation, which goes back to my original point that no matter how this court rules with respect to the second assignment of error, you're being asked to provide a merely advisory opinion that will have no practical effect in terms of reviving that claim, but for potential determination, I guess, where you're saying the summary judgment entry was not in full. I do believe it was. There were several different grounds on which we moved for summary judgment on the defamation claim, both with standing and on the merits. And I don't believe the trial court's required to specify all the reasons in her entry of why she found in our favor, but at the end of the day.
Well, I think it comes back to the summary judgment that was filed, because the magistrate and the judges later making determinations on what was filed, not on something that wasn't filed.
I agree. I do believe, though, that our original move, when we moved for summary judgment, it was pretty comprehensive, and therefore I don't believe that that claim is still before the court in any real way, especially not before the court with respect to whether it was properly dismissed as a discovery violation, because they have not also challenged and have therefore waived their right to dispute the dismissal of the defamation.
Understood. Do you want to go to the first assignment of
Yes,
error?
thank you, Your Honor. So moving to the first assignment of error, which concerns the amount of actual damages awarded to the appellee on her Consumer Sales Practices Act. Bear with me, there's a couple acronyms. The CSPA is the Consumer Sales Practices Act. That's the statute through which we get the treble damages plus attorney's fees, and there's many different ways to violate that statute. One of those ways is by also violating the Ohio Home Sales Solicitation Act, the HSSA, which is really at the heart of this dispute. And the HSSA is, like the CSPA, is a remedial statute that should be liberally construed, but I would argue is kind of a unique and special way in which you may violate the CSPA because it carries additional consequences that are significant in this case. The appellants are arguing that the mere failure to include the 3-day language is in of itself what we are challenging. But the HSSA, if you look at subsection B, as in boy, of ORC, subsection B of that relevant provision, you will see that not only are you required to provide the 3-day language, which really is to give a cooling off period. It's not a mere technicality. It stems from the FTC's cooling off period
What
designed.
about this argument that they had this cooling off because the work didn't begin for more than the 3 days that would be required under the notice provision?
So I will say that this is a strict requirement. There's no kind of compliance later after the fact. You either did or did not. And it goes so far, the law goes so far as to say that until you, as the contractor, provide the explicit 3-day notice, which, by the way, it's not a difficult compliance. The language is in the statute itself. You just have to copy and paste it into your contract. Until you provide that, the time to comply has not yet expired, and the cooling off period continues to run even if the work has already been completed, which is why it's such a significant and powerful statute. I recognize that. But it's very clear that until the contractor provides that language, that time does not expire.
So a homeowner could wait, let them perform the work, knowing that they didn't provide this cancellation notice, and then turn around and try to get treble damages as a result of that.
That's a very good point, Your Honor. So under the CSPA, you can either rescind the contract or seek damages. If you're seeking the damages, that's where you get the treble plus attorney's fees. If you rescind the contract, which I think would be arguably done in bad faith, if you wait till the end, there's no problems, then you try to rescind the whole contract, you actually can get your full amount paid back without any offset. If you seek the damages, and that's probably the issue here, is that if you choose damages and there's no problem with the work, then you're only entitled to the statutory damages of $200. However, if there are problems with the work, as there are here, and I'm going to come back to that in a second, that's when it really gets into the powerful impact of the treble damages.
And your argument is there doesn't have to be any causal relationship between the failure to provide the cancellation notice and the problems with the work.
That is not my exact argument. My argument is that if you don't have the 3-day cancellation language, and this goes back to what I was saying, the HSSA goes one step further. This makes it different from other technical violations of the CSPA. It prohibits the contractor from starting the work, starting the performance, until they've complied. To that effect, and this is really where it turns, they're essentially acting as a trespasser. And as a trespasser becomes liable for any harm caused while trespassing, then so too as a contractor who performs work without the authorization to do so.
So a homeowner who has hired a painter and allows that painter to start work on their home can argue that that painter is a trespasser.
Yes, and in fact, the case law expressly states that the contractor who chooses to proceed without complying with the HSSA's notice requirements does so at his or her own risk because it recognizes the significance and importance of providing this cooling off period. So if there was no reason, if there was no intent for a contractor to bear that risk, we would not have the case law that says that they bear that risk.
I'm not sure if this is the legal term for that, but it strikes me as a bit sneaky for a homeowner to be able to do that.
I absolutely agree, and that's why if there's no harm done, then they're only entitled to the $200 statutory damages. Exact same scenario if it's a trespass. For example, let's say I have
So I want
a,
to make sure I understand what you're saying. So there need not be a determination on the workmanship of the services of the paint job in this case, right? And that somehow gets collapsed into the hearing on the damages.
normally, in a case unlike this one, which we don't have, there's no contest, there's no dispute that there are damages. In fact, if you look at the appellant's own complaint, if you look at the appellant's own opening brief in this case, they acknowledge, they concede that there were problems with the paint job. We don't need to establish unworkmanship when they're already acknowledging that there were problems. The only dispute concerned the extent of the problems. Was it the full house that needed to be redone, or was it just a small area? They've never disputed that there were problems that needed to be corrected. The only dispute was about the extent of the damages, which is precisely what was argued at the damages hearing. So
The extent, well, it seems to me that damages hearing are to determine the monetary amount of damages.
Correct.
In this case, whether it needed a whole new paint job or not a whole new paint job, wouldn't that be something that would be presented on the merits?
I don't believe so. The merits go to whether there was a violation. The court found there was a violation and
Right,
ordered
a
a damage,
violation of the 3-day cooling off period.
which includes then the prohibition, the unauthorized work, which converts her into a trespass. If I can give you an analogy with the trespass, because there you also have nominal damages available when there's no actual harm. There's, just like you have the statutory 200 nominal damages available here if there's no harm. If I have a parking lot and you drive your truck across it, and no harm, no foul, technically you've trespassed, I'm entitled to nominal damages. If, however, I've just freshly poured concrete, for example, in my parking lot, and you drive your truck over it, and you create harm by your performance, by your trespass, you are responsible for the cost to restore my parking lot. The same is true here. If she had just done the painting job and there was no harm caused, then there would be purely nominal damages.
Would she be able to rescind the contract?
So my client technically could have, and we did amend the complaint because the reason for the amendment was to make the special election because you have to decide from the outset whether you're rescinding or pursuing damages. So we amended the complaint
So if
to,
they would have done a perfect job on the house, you're arguing that the homeowner could have sat back, allowed them to perform this perfect job on the house, and then rescind the contract and not pay for it?
under the law that was in effect at the time, yes. The statute has since been amended. The amendment took effect in September 2024, arguably in recognition that that kind of becomes a problem, and that's not a case that I think most attorneys, myself included, would be comfortable taking on because that just doesn't seem right. But this is a different scenario in which it's not that there was just perfectly performed work that then she just didn't want to pay for it. She did pay in full for it, and that's been acknowledged. There were problems that arose from it that had to be corrected. And again, there's no dispute that those problems exist.
Are there any matters that were left before the trial court after the determination on the summary judgment?
After the determination of the summary judgment or after the damages hearing?
After the determination of the summary judgment
Just the amount of damages.
and the motion to, and the motion to compel?
Motion to compel. The only issues that were, there were still other claims, but we would not need to pursue them. For example, breach of contract, because if we had obtained judgment on both breach of contract and the CSPA, just as in Fleischer versus George, we would have had to have elected which claim to pursue the damages under, and we would have chosen the CSPA simply because it has higher damages, frankly, and attorney's fees. So technically,
So in other words, you're counting on that with the CSPA that you can get these damages on workmanlike and get them multiplied, which you would not be able to do on the breach of contract.
correct.
So the breach of contract was left before the trial court.
It was intentionally left, and frankly, from our perspective, there was never a concern about being able to actually establish the breach. Going back to the discovery issues, we even had trouble just getting the other side to acknowledge that there was a contract in the first place. So that's why we didn't even bother with that, because there was a clear violation, and it goes one step further, as in Pat versus JW Roofing, where it's the exact same scenario. You have a violation of the HSSA by failing to include the 3-day language. that means the contractor is not authorized to perform the work. And when the contractor decides to perform the work, regardless of not being authorized, the contractor bears the risk and is responsible for any harm caused. Again, there's been no dispute that there was at least some harm caused, and that's why in the pre-hearing brief that the appellant filed between the time that the summary judgment was granted and before the damages hearing, they argued for the first time, frankly, challenging the unworkmanlike, the connection between the damages based on unworkmanlike performance and the 3-day notice. In fact, I would argue they've waived the right to pursue that argument at all because they did not raise it in response to our motion for summary judgment. If you look at page 20 of the appellant's opening brief, they cite word for word part of our own motion for summary judgment where we wrote that the appellee is, quote, entitled to treble actual damages and recovery of her attorney's fees on account of the painting of the exterior of their house that was done in an unworkmanlike manner. The opportunity to challenge that was when responding in opposition to our motion for summary judgment, and they didn't.
But if you're wrong as a matter of law, does it really matter if they responded to that?
I believe it's improper to then argue it on appeal if you've waived your right to bring it up in the first place. They did bring it up later, but by that point it was too late. There's no excuse for not bringing it up in opposition to the response to the motion, or in response to the motion for summary judgment. And as this court specifically held in B&T Business Ventures versus DC Brothers from 2022 Ohio 2113, when you don't raise an argument in response to a motion for summary judgment, you waive it. So they've waived the right. But again, even if you find that there's no waiver, and even if you want to find that proximate cause is required, it's been established here. There's no dispute that there were damages that had to be corrected.
Were they actually corrected? Or was that just an estimate that was submitted?
It was a pretty significant estimate, and frankly, because of the costs involved, my client has not yet been able to get it fixed. She desperately wants to, but she's waiting frankly, to be able to collect in this case.
So when we say actual damages, the estimate, how do you reconcile an estimate with actual damages? It's not like she's actually repaired the work.
So we had an expert witness testify during the damages hearing about the costs, what was required to correct the work, and then basically fix it all. So there was testimony. It wasn't just a written estimate. And I will point out that both sides presented witnesses during the damages hearing talking about the cost to repair, the extent of the damage, and so forth. So there's still never been a dispute that there was a problem with this work. It was painting, blistering, and it needed to be corrected, which again is the exact measure of damages that we're seeking here, the cost to fix the problem. So if there are no further questions, I would just request that with respect to the second assignment of error, either the court affirm or dismiss it as moot, and with the first assignment of error, to affirm in full. Thank you, Your Honors.
Thank you. You still have your 5 minutes.
Thank you. I'll note it first, and I'm sure the court's aware of this, but my client proceeded pro se for about 18 months in this case, and our firm didn't come on until after summary judgment was filed. We did, in fact, oppose damages in our summary judgment briefing. We filed affidavits, we presented evidence, but it was struck because of the discovery violations. So there was no waiver of any argument. We opposed the damages. We presented counter affidavits, but they were struck. So there's no waiver there. What I will note as well is that Your Honor noted that you could only move for summary judgment or grant summary judgment based on what's presented in the motions. And on the assignment of error number 2, that was specifically the Google review as noted, there was other claims that were pleaded, other claims were not moved for summary judgment, they were not dealt with by the court. That's our reason for assignment of error number 2. I think that is a relatively simple procedural issue to deal with. But the same rule goes for assignment of error number 1. If on assignment of error number 2, you can't rule on all the portions of the count that was not presented in the motion for summary judgment, you similarly cannot rule on everything that was not presented in the account for summary judgment on the counterclaims. And so, for example, I know Your Honors have read this, but Judge Giz specifically wrote, motion for partial summary judgment hereby finds said motion to be well taken and therefore grants Catherine France the motion as it relates to Defendant's Consumer Sales Practices Act counterclaim. She's referring specifically to the portion of the motion that was adjudicated and presented to the court, which was only the 3-day violation. And so that is the portion that went to the damages hearing. That is the portion that should have been considered. And there has never been an adjudication of whether or not it was properly performed work on this mansion in Indian Hill that she's saving up money to repaint. there hasn't been much discussion out of the rising of language of the statute, but, this goes to the crux of the issue as well. I mean, the statute itself says that the damages have to arise out of the injury. And in this instance, the injury is simply the right to cancel. Because the work began well beyond that period with respect to most of the work, and beyond the period entirely with respect to all of it, it doesn't arise out of. There hasn't even been an argument that says that it arises out of. There hasn't been an argument that said they would have canceled.
I mean, it feels as if what I'm understanding, the appellee Francis' argument is that where you have a breach of contract and you don't have the 3-day cooling off, that you could forego the breach of contract and just deal with it within the 3-day, within the CSP, within the CSP violation, yeah.
But I think to Your Honor Moore's point, that they've used the statute as a shield and a sword. It's no longer a consumer protection statute. It's the business person's attack statute, because they're using it as a way to say, you have this small violation. Yes, we have this other way we could go if we decide to prove it, but we're going to use this small violation and just heap all the damages into that one category. And it's patently unfair. I mean, my client, as Your Honors have known from the stay that was put on, she's filed bankruptcy as a result of this. So this has completely changed her life because of using the statute overly aggressively to pursue these damages. Now, had we gone back to a hearing and it had been fully adjudicated, and then so be it, that's the way it goes if we lose. And she'd have to maybe deal with the same reality had that been the case. But she did not have the opportunity to present her defense, and a large majority of that was because I think of their pro se nature of the first 18 months of the case. And that's a difficult challenge to face when you come in. I'm sure Your Honors have all been there, but you come into that situation, it's a difficult challenge to face. It doesn't change the fact that turning this into a trespass case is unrealistic. When they were paid, they were requested to come on to the property. There was a second contract executed for additional work, and all the while to say, I'm going to sit back and see how this goes, and if I don't like it, I'll get you on this technical violation. And then to acknowledge that the General Assembly says, well, that's a problem, we can't let people do that. Well, what I would say is the General Assembly never intended it in the first place. So if they came back around and said, we can't allow people to interpret this statute this way, we can't allow courts to interpret this statute this way, we have to fix this. And we're talking about the interpretation of the statute arising out of language, the application of damages, and the thing that matters, all the case law says, what is the intent of the General Assembly? Clearly the intent of the General Assembly was not to permit this type of action on a technical violation. Now, again, we'll concede. We could get remanded, and we could get the same result.
So,
At least we'd have our chance.
like, if there was a remand and you went back on, it sounds like all of your damages that you would have countered at the damages hearing were basically sanctioned out. Is that right?
So our summary judgment evidence was sanctioned out.
So, like, what would you even be litigating then? It seems almost futile unless you somehow got the gift of sanction forgiveness.
We were permitted to present some witnesses, but in limited capacity in front of Magistrate Baradon. We would ask Judge Giz to allow us to present the full scope of our witnesses and the full scope of our testimony. There was no particular order denying it. It's just for that particular hearing, Magistrate Baradon said that he was not going to permit the full scope of the testimony. So we would try to present the full scope of our testimony with all of our witnesses.
And what was his rationale for not allowing it? It was different than the dismissal?
I don't recall his exact rationale.
But you didn't get to put everything on.
Correct, and they objected to the presentation of it. We argued that we should be permitted to present the full scope of our evidence, and he limited the evidence that we were permitted to present.
This was for the summary judgment hearing, is that correct?
This was for the damages hearing.
For the damages hearing,
Yes.
okay.
Because I became aware when they gave me their witness list that they were going to go into the workmanlike damages, so I was like, well, shoot, well, we better make sure we're ready to do that as well. And so I had my clients there, and they brought one of their employees, but their testimony was limited in scope based on a ruling from Magistrate Baradon.
I sense that you may question whether or not there was an ability to pay for these damages. You had mentioned this was a mansion in Indian Hill. Did they actually have to cut a check to fix the work, or is the estimate sufficient to establish their claim for damage?
Candidly, I would argue that an estimate is not as reliable as an actual repair.
Sure, not as reliable, but is it enough?
I think a trial court can make that determination. I wouldn't say that it would be foreclosed based on an estimate. because at that point in time, this statute's not really designed to protect people who have means. It's designed to protect people who don't. I don't think, if I'm being honest, the General Assembly would have intended to foreclose someone who has to do a $100,000 repair until they raise $100,000 to do the repair.
Thank you for your argument this
Thank
morning.
you.
Thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision. Wish you both a wonderful week. Hodry versus Duke Realty. Attorney Finney, you can come up to the podium when you're ready. Good morning.
Good morning.
Would you like to reserve time?
I'm sorry?
Would you like to reserve time?
I would. In fact, I'd like to reserve 7.5 minutes because the
We don't do half minutes
counter
here.
appeal is a substantial.
Attorney Finney, we don't do half minutes here.
Oh, and we'll do 7 minutes.
All right.
If it please the court, may it please the court, I'd like to introduce myself, Christopher Finney. This is Julie Gugino, who did a lot of the briefing in this and has done a lot of the writing
Welcome.
in the trial court. Our client, Marcy Hodry, is in the back.
Welcome.
I think I'm proud, maybe, to have the oldest running case presently in Hamilton County to appear in front of you. Yes, it is a 2005 case. And this case involved two separate attempted appeal settlements, one in 09 and one in 19. The 09 purported settlement has an interesting timeline, which I'll get into, but essentially it was supposedly reached in 09. The motion to enforce that was not brought until 16 and decided in 18. So you can start scratching your heads about that one. That leads us to a settlement conference in front of Judge Catanzaro, who was a visiting judge in 19, that was read into the record. And in the record at that purported settlement conference, after a long day of negotiations, the judge asked my client, "Are you entering into this settlement willingly, voluntarily, knowingly?" And she says, "No, I'm doing this under tremendous duress."
Was that the end, was that the final statement she made?
No, it was not.
Did she eventually say she was not entering it under duress?
She did. She
And
absolutely.
she said that on the record?
She did.
And at the time,
Response to a direct question from the court?
It was, Your Honor.
and at the time, she was represented.
She was represented by, ably, some issue of conflict of interest, but ably by her attorney from Taft, Tennyson, Hollister. And there's no question about those facts. The transcript speaks for itself. And then there were ambiguities in that settlement. Two of them that the judge recognized and acknowledged. One dealt with an $850,000 tax issue, and one with a $150,000 payment issue. The settlement was for $232.35 million, the nominal settlement or the initial settlement, but there was a question about another $150,000 payment. The judge, we moved for two things. One was a hearing. We moved to set aside the settlement, and we also moved to have a hearing on that. The judge concluded that no hearing was necessary to determine that a settlement, in fact, had been entered into, even though, and we'll get to the legal standard on that, even though we had come forth with significant, both in pleadings and affidavits, questions about that settlement, the efficacy of that settlement. We also asked for a jury trial on those questions. We timely asked for a jury trial on that.
When you say timely,
That's a great question, Your Honor. Thank
So-
you for asking.
the original complaint, this is a settlement of the original complaint, which I assumed had a breach of contract?
Well, yes, that was
And
part of the
there was
claim.
probably a jury demand back in 2005?
I honestly don't know if the original complaint, it did have a jury demand, yes.
So when you say a timely jury demand, are you talking about as, in regard to the claimed ambiguities, the two claimed ambiguities, a jury was going to decide whether or not the tax issue, like they were going to construe that as a matter of a jury question?
Well, it's a great question, Your Honor, because we cite very clear law, which is Murray versus Murray and several other cases. Very clear law of the Ohio Supreme Court that says that if a settlement is at issue, is there a settlement at issue, you are required to have a hearing on that. And then, yes, on that question, is there a settlement agreement, there should be a jury trial available on that question, and that's under Civil Rule 1638, I'm sorry, Civil Rule 38. Every question
That's
that
why
can be
she's
submitted to
here.
the judge. Yeah, she's there.
Attorney Finney, you have 3 minutes left.
And then the second question is, should that be submitted to a jury? And the answer for that as well is that it should be submitted to the jury. Mr. Eisenson cites an entirely different line of case law that says, as to the enforcement of a settlement, that's an equitable action that's left for the judge, which gets to your question, Mr. Nestor, which is, if you determine that there is a settlement, then how is it to be applied? Perhaps. But as to the initial question is there a settlement at all? There's no question, and that's how I would reconcile those in two entirely different bodies of law. The ones that Mr. Eisenson cites on behalf of the defendant and us, which is extremely clear and repeated by the courts, that if the existence of a settlement agreement is at issue, they are entitled to a jury trial on that question, a hearing on that question, and then a jury trial on that question. The Maury versus Maury decision says, in order to legitimately dispute a settlement agreement, the movement must make an argument stating the basis for that, challenging the settlement agreement with sufficient specificity to put the opposing party on notice of the general and evidentiary bases for such a claim. And the appeal here today is both substantive and procedural. The procedural is we're entitled to a hearing. We were entitled to that hearing by jury trial. Substantively, interestingly, Judge Hine decided in our favor on a $150,000 issue. He said, yes, you were right, that there was an ambiguity, and that ambiguity falls in your favor, leading for a $2.4 million payment coming from Duke to Hoderi. But then on the other issue is quite interesting. The $850,000, and he said, by the way, that twice, he says in the decision that's de minimis. $150,000 is not a material part.
Attorney Finney, you have 1 minute.
Thank you. But on the other issue, it's quite interesting. The $850,000 issue, he decided in favor of Duke. And he said on that one, he said, this was a Trojan horse by the plaintiffs to attempt to get me to revisit my decision that in fact there was a settlement. So he comes at it from the backside and says, I can't possibly decide in your favor on the tax issue, because if I did, I'd have to overrule myself that there was a settlement at all, because he couldn't say that was de minimis. So the procedural issues are the hearing, which is quite black letter law, and the right to a jury trial. The substantive issues are the ambiguities in the settlement agreement.
I'll give you 10 seconds to
and
wrap
so on.
up.
Thank you, Your Honor.
All right,
Counsel, I'm
thank
sorry,
you.
just quickly, just to make sure I understand, the duress issue is off the table at this point, is that right?
It is not, no. The duress issue
Despite your client saying she was not under duress, the argument is
at
still
the hearing
remains.
itself,
Correct.
yes. Yes, we still argue that there was duress.
Okay, thank you.
And thank you, Your Honor.
Good morning. Would you like to reserve time?
3 minutes, please, Your Honor.
All right, thank you.
May it please the court, Dan Isaacson on behalf of the defendants, appellees, cross appellants, Duke Realty et al. Referred to them as Duke throughout the briefing, and the Hoderi estate, or the Hoderis, is the plaintiff in the matter. I'm here with my colleague, Bryce Yoder, who assisted with the briefing. Mr. Finney is correct. This is a 2005 case. Has to be, if not the oldest, one of the oldest cases in Hamilton County. There's one constant in this case, sadly enough, and that is Mr. Isaacson, myself. I'm the person who sat through this case from day one to today's oral argument. Mr. Finney, like yourselves, is looking at this with a lens of review. He wasn't at the 2019 hearing before Judge Catanzaro. He wasn't at the 2018 evidentiary hearing before Judge Catanzaro, which lasted 8 days. He was brought in after Earl Messer from Taft withdrew as counsel for Mrs. Hodery, and therefore he is effectively sitting in a review situation just like yourselves are. You had the benefit of a transcript from that December 2019 hearing, which I think your questions are appropriate. She did answer affirmatively, I approve. She did answer, I accept the settlement. I'm entering into this voluntarily at the very end. And that is why we believe the settlement should be enforced. I welcome any questions you may have. I think we've done a terrific job on the briefing to explain the issues. It's very complicated to unpack, so I invite any questions you may have.
So they seem to take issue with not having, well, both a hearing and it seems incredible that there would be a jury determination of the substantive issues here. But as to just having a hearing on whether or not a settlement was appropriate, should there have been something other than whatever it was that happened in front of the judge in the 2019 hearing where evidence was presented?
So as to the jury issue, that to me is a real easy issue to resolve. There's no right to a jury in a motion to enforce a settlement. It's an equitable action. Specifically enforcing a settlement is an equitable nature of the action. There's no jury allowed.
It seems like the Civil Rule 38 really speaks to the very, very, very beginning in 2005.
The underlying claim, Your Honor, exactly.
Right.
The underlying claim for breach of contract is a jury issue, but whether or not there was an enforceable settlement as a result of the on-the-record transcript that was taken is a decision for the court to decide, not a jury.
So what about having evidence put on about the understanding regarding the tax issue? It seems like there are two potential things that could have been the subject of the hearing: the tax issue, the Trojan horse of the tax issue, and the other $150,000. Why not have an actual evidentiary hearing?
We did, Your Honor. We did have a 2-day evidentiary hearing on those two exact issues. And the reason why we did is Judge Hine, very cleverly, he required the parties, first he took the transcript from the 2019 hearing, reduced it to a journal entry, took the terms from that settlement, put them on the transcript, put them on a record, and we were all then on notice of what those terms were. He asked the parties through counsel to submit ex parte what the terms of the settlement were to see where there was an agreement. It's very clever. And then the two issues that were still ambiguous in the mind of Judge Hine were the issue of the tax consequences and the $150,000. And that's what we had an evidentiary hearing on.
All right. And then, so in regard to that, you'd say that the requirement for a evidentiary hearing was satisfied as to those two issues, and then he resolved them, and that was appropriate, and those two issues should not be subject to some sort of retrospective 2005 original request for a jury.
Correct. There's absolutely no right to a jury trial on this motion to enforce. There is not. I believe, Judge Zayach, you had a case in the Connect case back in 2019. Every case before this court and every court of appeals on the motion to enforce is purely a gatekeeper trial court decision, seeing inequity. There's no right to a jury.
What about this question of the $150,000? Is that indicative of the fact that there wasn't a meeting of the minds? That's a big number.
Well, the $150,000 is on the transcript. The transcript, we believe, is very clear that it's inclusive of the $2.35 million amount. It's within that amount, so it's not a $2.5 million settlement overall. It's $2.35, which includes the $150,000 that was prepaid to the Hoderies as part of the settlement, and that's exactly what happened. There's also an email the day after the hearing in December 2019, which Mrs. Hodery acknowledges to her siblings that she agreed to a $2.35 million inclusive of the $150,000.
The transcript you're referring to, remind me which transcript that is.
The 2019 transcript from Judge Catanzaro at the end of the day.
And am I remembering this right, that I think there was a query from the bench as to whether the settlement amount was everything, and she responded affirmatively, something to that?
Yeah. There was a back and forth. There was a discussion between my client, Ann D., who was general counsel of Duke Realty, as well as Marcy Hodery. There was an acknowledgement that $2.35 million was the entire settlement amount. includes the $150,000. And that's the subject of our cross appeal.
And the tax issue, Duke basically promised to do what they could.
It's to provide cooperation, correct?
Right.
To minimize their tax consequences. Not to refile tax returns, not to amend tax returns. Those are all material changes that would have had to taken place. This tax issue had been present from a long time before this 2019 settlement hearing. And so it was known to them, they knew it, and this was the benefit of the bargain that they asked for, was our cooperation to help minimize those tax consequences.
I have a question with regard to the third assignment of error, and with regard to there was a motion to reconsider that was filed, right?
From the Hoderies?
Yes.
Okay, I'm not familiar what the reconsideration
Okay.
was.
Then you won't be able to answer my question.
Okay, thank you.
It's okay.
Thank you.
I'm just trying to understand where is a motion to reconsider rooted in the civil rules.
Yeah, it's a nullity. There was a lot of motion practice taking place. This case has a lot of history behind it. Not one deposition was taken in this case, not one.
See, and that's why I understand it also to be a nullity. So if it's a nullity, then it seems to me that perhaps the time has run with regard to that issue, because it was filed on the 30 days on the determination on this motion to reconsider.
They were trying to create a record of their rights on appeal. That's understandable, but in terms of the actual decision from the trial court, I think he acted like a gatekeeper, as he should, took in the information as he needed to, abuse of discretion standard for the ambiguities, and made his decisions based on competent, credible evidence. Unless there's further questions, I'll stand down and allow my colleague to go next.
Unless there's any others.
Thank you.
Okay, thank you.
Thank you, Your Honor.
You still have your
Mr.
full
Eisenson
8
said something
minutes.
as to the 2019.
I don't know if you heard what I said.
I'm sorry.
You still have your full 8 minutes.
Okay, thank you
Okay.
very much. Mr. Eisenson said something with which I agreed as to the 2019 conference with Judge Catanzaro that you cite from on the record, and the record is there for everyone to read as to what happened. But he said there was a lot of history there. And as to the $150,000, just that issue alone was very interesting, because there was $147,000 that was at issue at that hearing when they said, is this everything? And that was a dividend distribution, I think, during the time that was the current period. But there was another $150,000 check that had been issued to my client prior to that hearing. And Duke had written it to the wrong party. It was to a now non-existent former partner called H&R Limited Partnership. They wrote it to the wrong party, and they acknowledged in writing before that hearing, and I think in the settlement conversations that day before that transcript, that in fact that they would be paying that amount in addition to whatever was agreed to into the settlement. That was one of the two issues that was heard by Judge Hine. And in that conversation, in that testimony, he decided as a matter of fact that in fact the $150,000 was in addition. And so there was also a huge history as to the tax issue. The tax issue had been discussed since back in 13, and it was a topic in the 09 hearing, and it was discussed again in 13 extensively between the parties. And it was discussed that day and leading up to that day. So there was a lot of history that was subsumed in that, which is, sort of the parole evidence rule, that when you have an ambiguity, you let in those things, and that's what Judge Hine did at that limited hearing. Now, I believe, Judge Zayas, you asked the question, wasn't there a hearing? There was a hearing, but it was a limited hearing, and the judge had already made the decision before we walked into that hearing in writing. And he said, there is a settlement agreement, and I'm going to limit the conversation about this to these two ambiguities. Now think about that. We have a settlement agreement.
So is your position then you'd go all the way back to the beginning, and you'd have you'd go back to 2005, basically? All of this would be poof, and you'd go back and you'd litigate the contract issue?
Well, there's two.
Because your jury demand relates back to the contract issue, not to the settlement agreement.
No. We made a second jury demand in the pleadings with respect to the hearings on the settlement agreement. In the, I think, renewed motion, and by the way, that was before the close of pleading. Interesting point. You know, we had this hearing.
In terms of pleading, what do you mean? Isn't the pleading just the complaint and the answer?
The
and
motion to set aside.
It's a motion. You don't have a jury right to a motion, do you?
The Deaver decision says that you do. The Joseph versus Deaver decision says you have a right to a jury trial under.
Was the complaint in that case about the settlement agreement?
I believe so. I don't know the answer to that, but I believe so. But an interesting point is when we made the jury demand, why were we able to do that in the motion work? We did it because when the judge called for this truncated hearing, the issue of the motion to set aside had never been fully briefed. To this day, Mr. Eisenson has never tendered a memorandum in opposition to the motion for to set aside the settlement agreement. And the reason that he didn't was because the judges that preceded him put everything on pause until discovery on those issues that were at issue were addressed. And so it was never fully briefed. We opened the hearing in front of Judge Hine and said, we want to make sure we're preserving our right to a hearing on the existence, not on just these 2 points, but the existence of the settlement agreement itself. And he then said, let's proceed, meaning we're not going to have everything heard today. So when Mr. Eisenson flippantly says, oh yeah, we had a hearing, we didn't have a hearing. We had a hearing that was expressly limited with, first of all, with the assumption that there was in fact a settlement agreement, and he wasn't going to hear about the conflict of interest, he wasn't going to hear about the duress, and he wasn't going to hear about these substantive ambiguities, meaning when you get to the tax issue, an $850,000 issue that had been discussed for more than a decade, and in fact it goes all the way back to '03 when my client, before this litigation, brought to Duke's attention that the way they were taking, I think it was not taking accelerated depreciation, which discriminated against my client for their purposes, benefited Duke because they were the managing partner of the entity. And that was one of the issues in the complaint itself. So when the judge says this was a Trojan horse, I guess because you already decided that there is a settlement agreement, it's going to be enforced, and now I'm not going to hear anything that might interfere with that and have me lead to a different conclusion that in fact there wasn't a settlement agreement on which we were entitled to a full hearing. And he limited it to time, but he also limited to those specific issues. So Judge Moore, and this is my first time I think ever appearing in front of you, your question is quite appropriate. Ms. Hodery said on the record, after she said 2 or 3 times I'm under duress, and once I need a week or 2 to get through all of this, her attorneys, at the end of the day, the security guard's in the back of the room, and her attorney says, if you don't agree, this whole day has been a waste. You go, okay, I agree. And she did say that. There's no question.
And this is a very complicated case, and I'm trying to get some pieces off the board so I can get to the end here. At the end of the day, she said she was not under duress.
The transcript speaks for itself, Your Honor, and it says what it says. There's no question. You're correct.
Help me understand why that issue is still in front of us.
Because the next time we appeared in front of Judge Catanzaro and we said we had filed these motions, he said, I thought we would be here today. I thought we would be here today, meaning on a motion to reconsider the fact that there was a settlement. Because he knew, and everybody in that courtroom knew, that it wasn't final and it didn't include everything. And most importantly, it was ambiguous on these very key points.
No, counsel, my question is simply with respect to the question of duress. Why is that issue still in front of us when your client said she was not under duress at the end of the day?
I think it's entirely a legitimate, you have to have finality at some point, right, Your Honor?
And that's where my concern lies. There was a day-long settlement conference after which the parties reached an agreement, and ultimately your client said she was in agreement with that. And I'm struggling to understand why duress is still an issue that we have to deal with.
Thank you, Your Honor, for that, and let me give you a different example. I don't do any criminal law, never done it in my life. Had one or two little misdemeanor cases over the years. But I do sit in court and watch judges take pleas on criminal cases, and he asks all these questions. Are you under any improper influence? Anybody made any promises to you under any duress? Imagine, Your Honor, you're sitting here on a criminal appeal, and the record looks like this, and the criminal defendant says, I'm under a lot of duress. Oh, people did make promises to me. Oh my gosh, I need a couple weeks to think about this. Imagine you have a criminal defendant pleading to a life sentence, and he says to you, I was under duress that day, and I really needed more time to think about it. And you say, well, in the final thing, your attorney said you need to make a decision, client. What are you going to do? And he says, okay, I agree. Now, are you going to uphold that sentence in a hearing that's conducted in that way? I would not.
Okay, but that's not at all what I'm understanding the issue is in front of us. The issue in front of us is that your client was asked directly whether she was under duress, and ultimately she said no. Is that what happened?
That is what happened, Your Honor.
And so I'm struggling to understand why that issue is still before us.
And I'm telling you, other than the example that I just gave you, I fully respect what you're saying on that issue. I think that at some point, you have to have finality. What would I have done? What I would have done is said, we're going to take a breather, we'll come back in 2 weeks.
That's not what happened.
That's not what happened. But that's what I'm saying should have happened, because when you have a client who's under that, it's the end of the day, the guard's in the back of the room, the court reporter on the record says, I got to get out of here, what are we going to do? And my client says, okay, I agree. That's what we have.
Is buyer's remorse a legitimate argument against entering into a settlement agreement?
I don't think so, but I think rushing into it, and by the way, Ann Dee said on the record at the hearing that we had in front of Judge Hine, she says, as to the tax issue, she goes, oh, that was just thrown in at the last minute.
This rushing into it, so I want to address that for just a second. This was, what, an 8-hour session?
I believe it was an all-day session, Your Honor.
And in my recollection from practice is you're sitting back there during this 8 hours with your attorneys, and you're talking back and forth about the offers and counter offers and whether to accept or not. So I'm trying to understand how that's rushed.
Well, it was 8 hours, so I have some things to say about the 09 settlement in addition, so.
So is 8 hours rushed? Is that what you're suggesting, that 8 hours with counsel to be able to talk about the ins and outs of the settlement agreement is rushed?
We related an entire series of events where my client was preparing the day before. There were and the one most compelling is the misrepresentation of Nair that we put in the record of Duke, saying that they had an offer from Nair at so-and-so, and they emailed the judge the night before, copied us on that, of a certain amount. At the end of the day, after this settlement was reached, they said, oh, well, that offer, that's off the table now. Not those words, but something to that effect.
Just to keep,
So
just
the overall-
so you're apprised, Attorney
Please.
Finney, you're out of time, but whatever other questions come from the panel, they're welcome to ask and you're welcome to address. But after that, your time is
All right.
complete. Okay,
Thank you.
thank you.
The good and bad of being the lawyer for the last 20 years is I know too much. So, for example, when Mr. Finney says, Judge Catanzaro said, I knew you guys would be back here after the last hearing, I can tell you what he meant by that is because Marcy Hoodry reneged on the settlement from 2009, and he knew that she would do something similar in 2019. That's how I took it. It wasn't anything other than just that. The existence of the settlement agreement itself, it's not in dispute. Of course there's a settlement. We have a transcript from the hearing on December 20th, 2019, transcript of proceedings, settlement agreement. Judge Moore, you asked the questions about duress. I'll read to you. The court, I don't want you to say I was not understanding what was said because I was under so much duress. I want you to do this because you're agreeing voluntarily to do it. Are you agreeing voluntarily to enter into this agreement? Marcy Hoodry, yes. And you want me to approve it? Yes. There is a settlement. The only question is there any ambiguity in the terms of the settlement? There's two items which were ambiguous, according to Judge Hine. Those are two issues that we had an evidentiary hearing to discuss. Put on evidence, and he made his decision based on an abuse of discretion standard. We believe that he abused his discretion in failing to include the $150,000 within the $2.35 million that was the settlement sum, and we base that upon the fact that In the transcript itself, it's agreed upon that 2.35 is all in.
So is that an abuse of discretion or just a factual error?
It's so contrary to the terms of the settlement transcript itself, it is an abuse of discretion. And not only that, based on the transcript, but the email from Marcy Hodry to her siblings the next day affirms that. She even says 2.35 million includes $150,000. That's an abuse of discretion. I'm happy to answer any additional questions you may have.
All right.
All right, thank you.
Thank you. All right. All right. Well, thank you both for your arguments this morning. We'll take the matter under submission, issue a timely decision, and wishing everyone, including clients that are here, the best of the week.